This is Steven Leskin. I am the host of the Divorce Deep Dive webinar series. Tonight's topic is divorce and children. I am a divorce attorney in Portland, Oregon, and I host these webinars twice a month, usually on Thursday nights. And they are hosted on my website, leskinlaw.com. And what we do is we take an hour and go through a divorce topic in depth. So this is going to be an hour tonight on children and divorce, and the agenda is going to cover uh, custody, parenting time, and child support. Like I said, I am a divorce attorney in Portland, Oregon. I've been admitted to the Oregon State Bar since September 1992. I've been practicing family law since about 2001. I am the founder of One Day Divorce Mediation. My contact information is on the site. I don't take questions during the seminar, but seminar, but I do invite people to call me, shoot me emails if you have questions. I'm always happy to answer them if you told me that you've seen me online. So, what I do and will do for the next hour is explore one topic in depth. And I will go through and give people a straight view of what the topic looks like to a lawyer, what the law is, how this will impact your life if you're going through divorce and have kids or whatever the topic is. And it, it's intended as it's a lecture. It's intended as a lecture, and hopefully you will find this material helpful and come back to it um, as you need. So tonight we're going to talk about children, and obviously, children are integral part of divorce. If you have kids, uh, a lot of times I see families that are coming in, typical situation. Well, there is no typical situation. If couples got kids, then they're going to have to deal with the three issues of custody, parenting time, and child support. So with that, let's just jump right into custody. So the first question is, what is custody? And kind of, for a profession that uses words, uh, and for lawyers who pride themselves on being articulate and be able to express themselves, custody does not mean what you think it means. Custody means uh, possession, right? Like I have custody of these glasses. A police officer will take you into custody. Um, so custody means that there's possession, but the word custody is used in divorce means decision making. Custody means the person who has the right to make decisions. It does not mean um, who gets the kids, particularly, but it does mean who has the right to make the ultimate decisions regarding a child. And those decisions encompass medical decisions, educational decisions, religious decisions, to a lesser extent, where the child will live. And so um, the custodial parent has the right to make those decisions. We're going to talk about parenting time, and parenting time allocates where a child will be spending his or her days. So custody and parenting time are two distinct concepts. Uh, and um, it's important to realize that the custodial parent has the ultimate decision-making authority. But when a child is with a parent in parenting time, the, the, the parenting time parent has the right to make the day-to-day decisions regarding the child. So, for example, and we'll cover this in depth in just a little bit. Uh, when the child is with a parent on their parenting time, if they need to make a medical decision, they can make the medical decision. Uh, Things like that. Um, a major medical decision may need to be made by the custodial parent, but in the day-to-day application of the parenting plan, the the child's who the parent with whom the child is with has the right to make those decisions. Custody applies to both joint children and adopted children. Custody ends when the child turns 18. And 18 is a very important number for children. It's when they become adults. And the day the child turns 18 is the day they are no longer subject to their parents' custody. A step parent, by virtue of being a step parent, does not get custody of a child. There may be a way for a step parent to get custody. That's a different topic, but being a step parent doesn't confer legal rights, and a step parent will never have the same kind of custody as the natural parent. There are three types of custody. Uh, well, mom gets custody, dad gets custody, or joint custody. Only parties who agree to joint custody can have joint custody. A court cannot impose joint custody. I get a lot of clients who come in and say, "Well, I want joint custody with dad," and if dad doesn't agree, then it's not an option on the table. If you were to go to court and say, "Judge, can you impose joint custody on us?" The judge is going to say, "I cannot do that by law." So it's going to be mom who gets custody or dad who gets custody or joint custody if there's an agreement. And in just a minute, we'll talk about um, how somebody will get custody. I want to explain a couple of uh, concepts that are adjacent to custody. So, for example, I mentioned just a while ago that a step parent per se, just by virtue of being a step parent, doesn't get custody or can't get custody. But for people who have an close uh, uh, intimate relationship with a child where there's trust and a solid relationship, a person can get what's called third party custody. And so we do see third party custody with um, somebody going to court, particularly a grandparent or a step parent, where there's a need for somebody to step in, another adult uh, uh, can petition the court for um, third party custody, and Oregon law provides for that. Uh, that's different from a guardianship or adoption or conservatorship. And the way to explain these concepts, I got to use a metaphor. I got to use something that's similar because it will be easier to understand. If you bought a house and you told the realtor and you signed an agreement with the realtor and you say, "I want to put an offer on this house," and you are authorized to um, offer $500,000, right? You've given um, authority to the realtor to act on your behalf and to bind you on your behalf up to $500,000, right? It's a limited authority. The realtor may have some discretion. You could say, "Well, you can start, use your best judgment, but I don't want to spend over $500,000." Contrast that with going to the realtor and saying, uh, "You have my authority to do whatever you think is in your best interest." I misspoke. Whatever you think is in my best interest, right? So the realtor then becomes a fiduciary and has to objectively act in the buyer's best interest, right? So it's a fiduciary. In that case, you're saying, "I'm giving you fiduciary power." So a guardianship is more like the realtor who has authority to $500,000. An adoption is you become a fiduciary and you have the right to make all the decisions about the kids, but there's still fiduciary obligations similar to a conservatorship. So in an adoption or conservatorship, the authority is global. You have the right to make all of the decisions, whereas in a guardianship, the court will impose limitations on will impose limitations, but will grant authority for the person who gets the guardianship within certain limitations. So it's like the realtor that you can only uh, bid, for up to $500,000 on the house. That you have to act within that authority. Whereas an adoption or a conservative, you're you're obligated to act objectively in the best interest of the child. I hope that wasn't too confusing. So let's talk about a divorce case where there's a child and both mom and dad want custody for whatever reason. And let's say that the parents are both good parents, neither of them are impaired by drug use or alcohol or temperament. Uh, and so we'll take that and walk through what the court will have to look at to make a decision. I'm quoting here from a statute, and the statute is ORS, the Oregon Revised Statute 107 137. And if you want to find the statute, you can go to Google and type in ORS 107 137, and the statute will come right up. Uh, and so when the court is making a custody decision, this is the criteria that the legislature has laid out for making that decision. So the first thing to note is that uh, it's the best interest of the children. The standard is what's in the best interest of the children, best interest and welfare of the children. The court shall consider the following relevant factors: the emotional ties between the child and other family members. So this criteria is pretty straightforward. Uh, in deciding who gets custody, uh, does the child have siblings? Does the child have cousins? Does the child have nieces and nephews on both sides, mom and dad? And the court needs to consider what those emotional ties are between the child and other family members, particularly a sibling. So the question becomes, uh, which parent is fostering those relationships? B, the interest of the parties in and attitude towards the child. So I explain this to clients as, what are you doing to teach the children your values? What activities do you do to help the child grow into a healthy adult? How are you preparing the child for uh, adolescence or adulthood? And so what kinds of things do you, the parent, do to prepare your child for growth? And so the court will look to, like, what kind of activities do you do? What kinds of things do you do to teach the children social or technical or other skills? Presumably the kids are old enough, and we're not talking about 2 or 3 year old. But those are the kinds of things that are positive that a court will want to look at. Um, and there's a converse side to this, of course. Does a parent go out drinking at night and leave the children at home alone? Right? That interest of the parties and attitude towards the children. My young kids are okay alone while I go out and socialize at night. I mean, that sends a certain message to the court about interest and attitude towards the child. The desirability of continuing in his existing relationship. So this speaks to a couple of things. The way I explain this is uh, relationships with um, teachers, medical providers, friends in the neighborhood. Uh, what is the child's social network? This is really what this is asking: is what's a child's social and educational network, and which parent will best preserve or nurture those existing relationships, that social network. The abuse of one parent by the other. This is probably the hardest one, because what you get into, we're going to come back to abuse. Abuse is important here. Uh, um, and so the issue with this is that you have to paint the other parent, uh, as abusive. And you don't have to, but if it's in the relationship, it's going to get brought out by this. And sometimes it's very important for the court to know this. Sometimes it's not so important because of other factors. Uh, but it is certainly something that the court will consider and should consider, particularly if the abuse is systemic, consistent, and detrimental. The preferences for the primary caregiver of the child. Uh, so this means where the child is spending the most time, and who is taking care of the child, who's getting the child to school, who's taking the child to the doctor, those kinds of things. And court will give the preference to, and will designate who the primary caregiver is. Um, the last F, um, talks about uh, this is kind of going back to B, interest of the child. The court wants to see that both parents are encouraging a healthy relationship between the child and the other parent, right? So if a parent is denigrating the other parent, uh, the court you, the court will look down on it as it should, because it's taking away from the other parent, right? It's undermining the other parent. The courts want to see that both parents are encouraging the children to love both parents, and not undermining the authority or the love of the of the other parent. So that's what F gets at, is that uh, is are both parents being supportive of one another and still fostering, even though they're getting divorced, still fostering um, a healthy, loving relationship with the soon-to-be ex-spouse. And as we just talked about, um, if there's a continuing pattern of abuse within the relationship, that will count against um, that parent who's being abusive. So let's continue. The statute continues on. The best interest and welfare of the child in a custody matter shall not be determined by isolating any one relevant factor. So the court is required to balance all of the factors that we just went through. It's not enough to single out one or ignore one or two. The court has to do an analysis of each of these, weighing one against the other in making its custody determination. So a court could not say, well, this parent is showing a lot of good interest in the child by taking the child fishing once a week. It has to be a global consideration of all the criteria that the legislature has laid out. Um, this, however, is important, and the statute that is being referred to here, 107705, is the Family Abuse Restraining Order. So if it's shown that um, a FAPA has been awarded against one parent, so the parents have gone to court and one of them has a FAPA restraining order, it's a rebuttable presumption that it's in the best interest of the child that the other parent should have custody. So the court has determined that one parent has been abusive. It is a rebuttable presumption that the other parent gets custody. And rebuttable presumption means that uh, um, it's going to that other parents unless you can overcome um, the presumption, right? So I didn't explain that well, but I think you get the drift of what I'm trying to articulate. In law, we don't consider character. uh, Somebody could be an awful person in a personal injury lawsuit, and their character, and they're in a car accident and they hurt their neck. Whether the person's a so-called good person or a bad person, we don't consider that. If somebody is up for before the court on a criminal case, supposing they've been accused of criminal trespass or menacing or theft, we don't consider whether or not somebody's a good person or a so-called bad person. We don't consider character. That is a bedrock principle of law. A lot of times, people want to talk about how evil the other parent is. It's not relevant. It doesn't matter. What counts is conduct. And here, one of the few times in law where somebody's conduct kind of globally comes into play is in determining custody. And this part of the statute, we're still in 107, 137. The court shall consider the conduct, marital status, income, social environment, or lifestyle of either party only if it is shown that any of these factors cause emotional or physical damage to the child. So there's a little bit of a caveat at the end. So uh, somebody could live a lifestyle where there's a lot of pot in the house, right? There's a lot of smoking, and or even tobacco. and that's a lifestyle decision, and a kid has asthma, right? So the lifestyle and conduct of the smoking parent will come into play in determining custody. Uh, Other lifestyle uh, changes may, um, well, drug use is the best one. Us just stick with that. So that's an example of where it's conduct. It's not necessarily character, but it's conduct. So you could argue the spouse. Uh, there's a lot of smoke in the house. There's a lot of the child is exposed to a lot of secondhand smoke. Uh, as a result of lifestyle decisions and that conduct, and that's physically damaging the child. That will count in a custody decision. The court will consider those kind of lifestyle and conduct when determining custody. The statute continues that um, mother and father are treated equally in the eyes of the law. Both parents could be the custodial parents. There's not a there's no legal preference for the mother. However, courts for years have had psychologists come in and say a young child needs a nurturing parent, and the mother is more nurturing. And it's I don't know if I think it's biologic. I don't want to get into an opinion here. Uh, but women and mothers tend to be more nurturing as people than men, and um, that's what younger children need. They need that nurturing. They need that particular type of intimacy, and there's science behind that, and a lot of child psychologists have testified before a lot of judges, and so um, a lot of times the decision may be neutral. I mean, the decision maker may be neutral and independent, but there's still the preference for the mother, and it's out of that strong belief that a mother's nurturing is more in line with what a younger child needs than a father. The mother is able to provide that is able better to meet the emotional needs of the child more so than the dad, and so there's a perception that moms have some advantage in custody disputes. All things being equal, there is, I think, some truth to that, but it's fact specific to the people, the parties, and the environment and the situation. But I think that there is that bias, even though the bias may be grounded in some fact and some serious, consistent professional opinion. And then the custody statute ends with this line: a denial of custody under the subsection does not relieve the parent of any obligation to pay child support. Custody decision, uh, uh, unfavorable custody decision does not relieve a party from their obligation to support a child. Oregon law provides that parents are obligated to support their children regardless of who has custody, but it's an affirmative obligation under Oregon law. And this subsection just clarifies that. We've been talking about how the courts will decide custody. We're going to switch it up a little bit. And um, we're going to talk about what are the rights of non-custodial parents. So mom gets custody, what are dad's rights? There's a mistake here. It's ORS 107-154, not 1545 on the slide. Um, so the right of the non-custodial parents is an informational right. I'm going to say that again. The right of a non-custodial parent is information, right? A custodial parent may not withhold information about the child from the non-custodial parent. So, for example, the non-custodial parent has the right to receive school records and to consult with school staff concerning the child's welfare and education to the same extent as the custodial parent may. So school records are uh, fully accessible by both parents. Same with government agency and law enforcement records concerning the child to the same extent that the custodial parent. So this might be DHS or if there's juvenile conduct, both parents have a right to see the police reports or the agency reports. Um, Thirdly, is medical, dental, and psychological records. Both parents have the same right to see those records. And finally, uh, both parents have the right, and this one is not informational, but to authorize emergency medical, dental, psychological, psychiatric, or other health care for the child if the custodial parent is, for practical purposes, unavailable. So I said this a little bit earlier. Uh, the non-custodial parent, and it's just common sense, right? That in the event of an emergency, medical emergency or something else, the non-custodial parent can, of course, make emergency decisions. But outside of that, the other rights are informational. Let's talk about modifying custody. So let's suppose that it's 2025 and two parents have gone to court and they've argued about custody and the judge made a decision in favor of mom. Mom gets custody. But it turns out that mom's not doing so well after the divorce. Mom's drinking a lot. She's not never at home. She has a Dewey, and the children are not being fed and not getting to school. Father's response is, and prior to the divorce, mom was a good mom, but mom just the marriage fell apart, and she hasn't been the same. She hasn't really recovered. Um, and so in those circumstances, the father can go back to court and say there's been a change of circumstance. Mom has deteriorated. And now it would be in the children's best interest for me, the father, to have custody. So the two things that have to be shown is an unanticipated change of circumstance first. And then the second is the change is in the child's best interest. And so custody may switch from parent to parent over time. The change of circumstance has to be significant and such that it's no longer in the children's best interest because of the change. It's no longer in the best interest of the children to be with mom. And so under that circumstance, the court will change custody. Um, uh, but the circumstance has to be something that goes to the kid's welfare. It cannot be, um, you know, mom got demoted at work. Mom's still a good mom, but mom got demoted at work. Therefore, that's a change of circumstance. Well, if mom's still providing and being mom, then that change of circumstance isn't going to get you anywhere. So it needs to be a change of circumstance that goes to the kid's best interest. Okay, so that's enough about custody. Let's switch to the other part of the discussion, which is parenting time. So custody, as we talked about, was the right to make decisions. Parenting plans allocate, right? Parenting plans dictate where a child is going to be spending time. So we all know a typical parenting plan, right? Dad gets the kids every other weekend and once a week on Wednesday nights, and then uh, you know 1 year in the odd number of years, dad gets the kids on Christmas, and mom gets the kids on Christmas on even number of years, and they switch off year to year. Thanksgiving, dad gets it on the even years, mom gets on odd years, whatever it is. So we all know that is the standard parenting plan. Uh, Parenting plans have grown more sophisticated than that, thankfully. And parenting plans now are expected to evolve. They're dynamic. They're intended to be dynamic and to grow. It's anticipated that parenting plans will get changed over time as the kids grow and mature. And uh, uh, so uh, the standard has come to be thought of as the standard parenting plan is really not so much a standard parenting plan anymore. They're more tailored to the specific relationships between parent and child. A couple of starting observations as we get into it. And as I just indicated, the parenting plans evolve. As children age, they have more input. When a child is young, 5, 6, 8, they don't have any input. They, their opinions don't count. If a child does not want to go to mom's house for the weekend, it's kind of too bad. That's where the child has got to go. Absent abuse or something terrible. Uh, the um, Even with the child screaming and crying and I don't want to go, you got to go. And it's the obligation of both parents to make that work. It's a team effort to make that work, even in a divorce. And so the as the child ages, the child gets more input. The child starts hitting 14, 15, 16. The child, will start getting will the child's opinion will start being given more deference. So um, the parenting plan is intended to evolve. The other thing I would say is that parenting plans are worst case scenarios. Oftentimes, and I've seen this time and again, um, uh, parents are not, they've just gotten divorced, they've just spent a lot of money on lawyers, or, something terrible has happened and it's resulted in divorce. And the lawyers have been, hurtling insults at one another for, months. Uh, and then, so, naturally they're not getting along. But, eventually the two people, at one point they saw something in one another that they loved. And eventually they're going to come back and find an equilibrium. Right. And so as the wounds heal and as people start to see what they, found in their spouse, their ex-spouse, they start to be able to parent well together. And some parents, are always able to parent well. But the parenting plan exists to guarantee to both parents a relationship with their child. Right. So if the parents like want to switch weekends, nobody cares, right? Just do it. Uh, but if, on the other hand, if mom is saying no, you can't have the kids this weekend, period, then it's the parenting plan that controls, and you can go to court to enforce that. And I'll come back to that in a bit. So parenting plans are for worst case scenarios where people just aren't, they're still not getting along, they're not getting along, but there has to be some law in place to preserve both parents' relationship with the child. Um, the parenting plan has to be in the child's best interest. It's not in the, even though it's preserving the parents' relationship, it's still what's in the child's best interest. As I just mentioned, if parents agree on change or on a temporary change or a permanent change, they can ignore the parenting plan. If they do not agree or they can't agree, then they need to go back to court to change and modify the parenting plan. They don't need to go back to court if they can do it themselves. They can just file the revised parenting plan with the court. If they go to the county and the county courthouse and say, we need help with this, the counties will provide mediation almost throughout all of Oregon. And if you come to an agreement, you file it with the court, and um, that memorializes the change to the parenting plan and keeps the court apprised. As I talked about just a little while ago, as the kids age, it's anticipated that the parenting plan will need to change to modify the children's interests, the parents' interests, and just change a life circumstance in general. And it's possible to modify a parenting plan the same way that it was possible to modify custody, except that you don't have to show change of circumstance. You have to show that the current parenting plan is no longer in the best interests of the child. And that's the standard for modifying um, the parenting plan. What's in the parenting plan? Besides a schedule of where the child will be at any particular time, or who's going to pick up from where the exchanges are going to be made, those types of things. When a child may communicate with the other parent, there may be provisions for international travel. For example, parenting plans can require that the traveling parent provide a full itinerary, uh, um, get approval from the other parent. Both parents need to sign off on the passport, but there still may be other travel restrictions or requirements in a parenting plan. Parenting plan may cover tobacco and alcohol use in the home. So, for example, if a parent is a heavy smoker and the other parent objects to the child being around secondhand smoke, there could be provisions in the parenting plan that provide that the smoking parent will not smoke within 24 hours or 36 hours or whatever, that they will have parenting time, or that they will not expose the child to secondhand smoke. Same thing with alcohol use. If alcohol or drugs are an issue, there are ways to monitor for alcohol and drug use. There's companies now that provide monitoring, relatively inexpensive monitoring of alcohol and drug use, and uh, um, that can be specified in a parenting plan as well. Usually, my experience, uh, um, those types of requirements or wishes are very heavily contested. Nobody wants to be monitored, especially if they really are drinking a lot. Uh, Things like parental dating, the newly single spouse wants to get out and be social again, or um, start, finding new love. Uh, there may be mutual agreement on how the children will be exposed to that, on what conditions the child will be exposed to that. Um, so, that's something that is often discussed in a parenting plan. Uh, a typical parenting plan will have a non-disparagement clause. A parent cannot refer negatively to the other parent. And that's kind of common, that not kind of common sense, it is common sense. The children need to be raised in a loving environment, even if the parents are divorced. And a non-disparagement clause says that you will not say bad things about the other parent in presence of the child. You do that to your friends, not to the child. Another issue is particularly if there's abuse of the child or the parent, or there's sufficient distrust. Um, a parenting plan could require either a professional or a non-professional supervisor, right? So there's DUIs and other alcohol issues. Um, the parenting plan may require, or abuse issues, the parenting plan may require that the one of the parents pay for a professional parenting time supervisor. The cost could be, $150 an hour or $150 for 2 hours. So it can be significant, but sometimes that's required um, in order to in order to keep the children safe. Travel arrangements. If somebody is living out of state, if one of the parents is living out of state, excuse me, uh, uh, a parenting plan might provide that the one of the parents has to provide a third party to travel with the child, particularly if the child is young, who will pay the travel expenses, uh, who will get the itineraries, those kinds of things. So if there's travel involved, that can get pretty detailed in terms of um, how you're going to make sure that the child is safe during their travels. Um, Another issue that comes up is that uh, you know mom has remarried, and now new husband wants the child to call new dad daddy, right? And it's kind of offensive to bio dad. A parenting plan could provide that um, the parents will refrain from using any uh, father, mother type designators to the new spouse, and that's something that's reasonably common in a parenting plan. Uh, Most attorneys draft their own parenting plan, and so it will just be a document that lays everything out. There's some alternatives to that, and I frankly have started using one parenting plan uh, that's produced by the Oregon Judicial Department, and you can find it by going to the Oregon, typing into Google browser, Oregon Judicial Department parenting plans. Those parenting plans are particular to the age of the children and whether it's a local or long distance relationship, and they're pretty detailed and pretty clear and easy to use. So I like the Oregon Judicial Department parenting plans, and I do use them sometimes in my divorce cases, or we'll use them as a template to get an agreement, and then I can write it up into my own parenting plan. But it's a good framework for making sure that I've got everything covered. Local courts, you can go to the local court websites, and there's a family law section in almost all the Oregon venues at the circuit courts, and they'll have sample divorce documents, including parenting plans. They're not as good as the OJD one, the Oregon Judicial Department, but some of them are certainly workable. So you can find parenting plan samples online. And we've been talking about divorce. This is also true in cases where there's not a divorce, where there's, child is born outside of a marriage. All my comments apply to both divorce and custody cases. And let's talk about enforcing parenting plans. Oregon law provides an expedited parenting enforcement procedure. If you don't want to hire a lawyer, uh, and you just like dad's not bringing the child around on the weekends, or not returning the child on time consistently, or is smoking, in presence of the kids when the parenting plan says no smoking. You can go to court. The courts will provide you with the forms to get an expedited parenting enforcement uh, uh, motion before the courts, and you go in and say, "This is what's happening. This is my evidence." The father, in this circumstance, gets to come back and say, "No, no, no, that's all wrong. This is what's happening," and the court will say, "Don't do that again." And then, if it happens again, then the court will start imposing financial and other sanctions, including dwindling and reducing the offending parent's parenting time, and that's reasonably straightforward. Um, the other option, it's not really done that much, is you can file a contempt action for a parenting plan, not so much, but that would be the other option. So use the expedited procedure to enforce a parenting plan. And if you need to, you call the courts or just go online and find the paperwork for that. All right, we're going to get into child support, the final issue. Excuse me while I scratch my nose. Uh, So I'm going to contrast child support and spousal support. Uh, Spousal support is a negotiated amount. There's no formula out there that says uh, parents who have been married this long and make this much money shall pay X number of dollars in spousal support, right? It's a negotiated amount. Whatever the two parents come up with, or whatever the court orders after hearing argument, taking evidence, that's the amount of spousal support. Oregon law gives really broad guidelines on how to determine spousal support and what factors need to be considered in terms of like what property, what are the savings, what are the other sources of income. Uh, but child support is different from that. Child support is set by statute. It is not a negotiated amount. You do not sit down with your spouse and say, how much child support are you going to give me? Right? It's set by statute. And that's a good thing. That means that we're not arguing over what the child is worth. Uh, uh, the way to determine child support is in Oregon, it's universal. Everybody does this. Everybody does it this way. Is you go to the Oregon Department of Justice website, and there's a child support section. And within that child support section, there's something called a child support calculator. And so you will put in your inputs and it will give you a number. And that's the way child support is calculated in Oregon. In fact, every judgment in every custody and divorce judgment, the child support calculation has to be printed out and attached to the judgment so that the court can see what factors were used to determine uh, how child support was calculated. The amount of child support is based on a couple of pretty straightforward factors. Uh, the income of both of the parents, how many overnights the child has with each parent, whether or not the parent receives or pays spouse support, whether or not the parent pays union dues, whether or not the whether or not the parent pays childcare costs, and finally, the amount that the parent, the amount that it costs for a parent to insure the child. So all of those inputs go into the child support calculator, and it spits back a number, and that's the amount of uh, child support. Um, you oftentimes the dispute is over, for example, how much money or what constitutes income, and the Oregon administrative rules get into that. There's no reason for me to get into that here, but the rules get very, very specific about what constitutes income. Generally, it's W-2 income or 1099 income. Uh, if you have investments, that comes into so. Uh, um, the amount of income and the amount of overnights are the two most controlling factors for the amount of uh, child support. So if if both parents made about the same amount of money and the amount of overnights was equal, there would be no child support, for example. Not surprisingly, child support ends once the child turns 18, unless the child is a child attending school. And what that means is that until the child, if the child is attending an accredited school or vocational institution and is attending more than half time and has passing grades, the child is entitled to receive child support from both parents. The child support calculator will tell both parents how much they each have to pay to the child, and that's child support to the child support paid directly to the child, unlike child support before where it was paid to the other parent. Now it's going to go to the child directly. In a case where a child is parents have a child who's 18 or about to turn 18, that child will be included as a party to the divorce because they have an interest in getting their child support. That child support ends at 21. Uh, there are weird constitutional issues about this. The child's an adult, you know, duty to support ends once they turn 18. But the law is that if the child's attending school, you're obligated uh, um, uh, to pay child support. Payment of child support. There are a couple different ways that child support can be paid. One is one parent writes the other a check, and that constitutes child support. It could be through wage withholding, which means that um, there's a the court signs a wage withholding order that goes to the employer, and the employer pays the support directly to the other parent. The third way is paid through the Oregon Department of Justice, and that also could be through wage withholding. The parties will set up accounts with the Oregon Department of Justice, and um, the Oregon Department of Justice will collect and then distribute the child support. And generally, if I'm doing a divorce for somebody, I always encourage, it doesn't cost anything. There's always a record. Uh, the agency is involved. It's an invisible process, but they do the accounting. So there's never a dispute over what was paid or what was not, almost never. A dispute over what was paid or what was not paid. And in the end, it turns out probably to be the most convenient way to monitor and track payment of child support. Uh, it's sometimes the case that uh, there's a reason to modify or not pay child support. Those reasons are very limited. There has to be a showing of unjust or inappropriate, that the child support is unjust or inappropriate, and it's per the Oregon administrative rules. Um, a, a court can only deviate the payment of child support based on that standard, and a judgment needs to lay out what is unjust or inappropriate. Uh, an example: of that is I recently handled a case where um, wife, husband transferred 7 paid off homes to wife, right? So the wife was going to have a healthy, steady stream of income. There was just, which was more than enough for the family to live on, and there was just no reason for the father to pay more since he was transferring an income generating asset to the spouse. So that would be a reason for deviating child support. Some other reasons may be a parent is incarcerated. That would be it would be unjust and inappropriate to pay child support. A parent may be incapacitated and unable to work. That may be another situation where um, child support is not warranted. Uh, Unlike spousal support, there are lots of different ways to enforce child support payments if the child support payor is not paying. Uh, the Oregon Department of Justice has a lot of tools at its disposal to enforce payment, and those tools can include suspending a professional license, intercepting tax refunds, uh, garnishing wages, and particularly garnishing interstate wages. Um, so there are a lot of tools for the Oregon Department of Justice and also the county district attorneys to use to enforce child support payments. There is also a crime in Oregon not to pay child support. However, the only time in my experience that a prosecutor will take a case like that is if there's like neglect or some other crime that accompanies the non-payment. It's just not going to happen. There's DOJ has too many other options to pursue child support that a criminal case is going to be brought against a non-paying child support payor. All right, that's it. That's everything you want to know about custody, parenting time, and um, child support. You have been a wonderful audience tonight. I've appreciated that everybody's here and watching. It's been a great turnout tonight. Again, if you have questions, please feel free to email me or give me a call. I'm happy to go through things with you. And I hope this has been helpful. Thank you for watching.